what are common mistakes you think people make?
One of the other main issues or mistakes is just trying to do too much yourself. We have connections for a reason. And so trying to do the probate yourself, trying to file the taxes yourself and sell the real property yourself, that's so hard. I really encourage all my clients to find great realtors like you and CPAs and other people that they can trust. I know that you know people that can help clean out the property, deal with estate sales and everything.
Yeah. So today I'm here with the great Cassy Walsh from Woodburn and Wedge. You're an expert in estate planning and probate, all things with estate planning and probate. So thank you for being here, Cassy. Tell us a little bit about yourself.
Yeah, thank you for having me. I'm a Reno native. I'm born and raised. I attended the University of Nevada, Reno. I obtained my degrees in finance and management there. And then I went across the country and attended law school in Boston. I came quickly back and I've been working for Woodburn and Wedge since. Woodburn and Wedge is a great local firm. We've been around for I think almost 110 years in the Reno area, and I'm within our estate planning, trust administration, and probate practice here.
Wow, that's incredible. I didn't know they were around so long. So is Woodburn and Wedge like the longest law firm in town?
Yeah, they're the oldest law firm in the whole state of Nevada.
Wow.
Yeah,
That's
so
incredible.
they mostly started to do, their clients were miners. So it was mining claims and kind of all, I don't do much of this. So all the land regulation with that, and then started to expand.
Wow, that's incredible. That's pretty neat. Well, I'm really excited to talk about today's topic, which is probate. Unfortunately, so often a lot of our clients come to us and maybe they don't even know they have a property in probate, right? They're just trying to sell mom or dad's property, and then they find out they have this whole probate thing, or somebody passed away that owned it with them in the past and they weren't aware of it. So I'd like to, for people who don't know what probate is, just kind of give them a description of what probate is.
Yeah, that happens all the time where children try to sell their parents' properties. And essentially, that's when you call me or one of the other estate planning and probate attorneys in town. So, probate is the legal process of administering a deceased person's estate. This involves settling the deceased person's debts and distributing their assets according to either their last will and testament or by statute. If there is no last will and testament, they're called intestacy statutes, where our legislator has gone out and essentially decided what happens with people's assets if they die without a will. Probate is overseen here in Washoe County by the Washoe County Probate Court. And it is managed by either a personal representative if they're appointed in the will, or an administrator if there is no will.
Oh, wow. Okay. Yeah. From my experience, it's always like pretty expensive to have to go through probate, and also pretty long. So if somebody has to go through probate, how long does the process typically take?
The length of probate depends on how big the estate is. So in Nevada, there are 3 levels of probate. If we have estates that are worth under $100,000, it'll take us about 6 weeks. It's just a one and done petition. But when you're dealing with real property here, especially in Washoe County, you are not going to see property that's worth less than $100,000 unless you bought the property last year and there's a huge mortgage on it. The next level, we call it the summary administration. That is for estates that are worth between $100,000 and $300,000. The summary administration, it doesn't take as long. The court isn't too concerned with a lot of oversight with those types of estates, but you're still looking at about 6 months. For estates that are worth over $300,000, you're at least looking at about 9 months. A lot of people, when they do come see me and they hear that they have to do a general probate, I don't know if maybe it's just from movies or reading scary articles online, they think that they're going to have to do this for 5 years.
Right.
It doesn't take that long. I want to get the probate done just as much as my clients want to get the probate done. And so we would like to do it as quickly as possible. The reason why it takes so long is we have to file a lot of petitions with the court and we have to notice a lot of people. So generally, it takes about a month to get a hearing in general to even start the probate process. Then we need to, during that time, notice all the beneficiaries, everyone who's going to receive parts of the estate. Once we finally get someone appointed in charge of the probate, we then have to notice creditors. So you're adding another 2-3 months to deal with that. Then we need to tell the probate court what's a part of this estate, what's the inventory. And then after that, depending on how long, we need to do a first account and let the court know what the administrator has spent on the probate, what's come into the probate. And then eventually we can request for a petition for distribution. So there are just many, many steps during this process. And like, I read these statutes for fun. I don't expect any of my clients to sit there and read through these statutes.
Yeah, it's definitely not something that you would want to try to do on your own, like a file for probate by yourself, because if you miss those timelines and it could take even longer.
Yes, I think the biggest mistake kind of that I see is just not knowing who you're supposed to notice. So you might have kind of like the example we were talking about at the beginning. So we have the siblings that they want to sell their parents' property. So they might go down to the court, file themselves, but they forgot to let their other siblings know about it. So now we're going to add on extra time to properly notice the siblings. You have to notice the Medicaid here in Nevada and make sure that there aren't any claims against the deceased there. So it's really hard to do on your own. As an attorney, of course, I'm going to say, come see me to do this probate, but I went to law school for a reason, to learn all of this stuff. And so I don't expect people to know everything.
Sure. Yeah, there's a lot of moving parts, what I've noticed. And what are common mistakes you think people make? Is it just not knowing there's a probate, or like what would a mistake somebody would make during the probate process maybe?
Yeah, I think that a lot of times people just don't know. They don't know what they're supposed to even start with, and so they might sit around for a couple years, and mom and dad's house is paid off, so we don't have any concerns with the mortgage company. But eventually, when you sell, like, though, all these problems are going to come back. I would say there's always going to be, I don't really know if there's a definition of a smooth probate. There's always going to be kind of bumps in the roads, up and down. I think the first mistake is trying to start the probate process too soon. People, their parents pass away and they're really concerned and they want to get it going. And I completely understand that. But we need to wait the 3 to 4 weeks to even obtain a death certificate. So I think trying to start too soon, starting too late, we can always fix it. We, at my office, we just probated a property of someone who passed away in 2003.
Oh, geez.
So it happens. So I guess maybe not even a mistake during the probate process, but what everyone should do is double check how they're holding title on their property. A lot of people, when they purchase properties, they think they're holding it jointly with their spouse or maybe even a sibling or a friend, but they're actually owning it as tenants in common. So that means when that person passes, their interest doesn't pass to the survivor. We have to probate that
Sure.
interest. So I guess just a general reminder, let's look at our deeds. Let's see how we're holding the property. One of the other main maybe issues or mistakes is just trying to do too much yourself. We have connections for a reason. And so trying to do the probate yourself, trying to file the taxes yourself and sell the real property yourself, that's so hard. I really encourage all my clients to find great realtors like you and CPAs and other people that they can trust. And I know that you know people that can help clean out the property and deal with estate sales and everything.
Yeah. Yeah, that for us on my side of things, that's what we do to make it really convenient, is like basically they could hand us the keys and we can just take care of everything, getting rid of the personal property inside the house,
Yeah,
Recently, we did one where we sold cars for the family and we haul away any unwanted items, whatever they need. And many times we can help them when they're in other states. Because I noticed some people, inherit properties, they don't live in the area, and they need somebody here to facilitate a lot of those things. So that's what we do on my side. Sometimes, though, I find the state, like the heirs to the estate or the administrators, wind up throwing away important documents that they
yeah,
need, or not keeping track of all the accounts that the decedent had. And so that could be kind of frustrating for those people because they can't just call the bank typically unless they already have those letters of administration and everything, and then get it. But that's a whole nother process.
it is. So when we file that first petition, we ask the court to appoint someone as a personal representative or an administrator, and then ask the court to allow letters of administration or letters testamentary to be issued. And so those couple weeks sitting there waiting for that to happen, it's hard because you might be receiving letters from the mortgage company asking for payments, or all of a sudden, mom and dad's bank account that was paying for the power and the water and everything, now it's been frozen. So I don't, if that's not really a mistake that people make, but just a big obstacle that they have to deal with.
Right. That's super frustrating for somebody who inherits a property and then they have to still like pay the mortgage and keep everything current while they're starting the probate process.
Yes,
Yeah.
yes. And personal representatives and administrators, they will always be reimbursed for the expenses they personally deal with the probate. They will never come out of pocket for anything. It is a bummer when you have to do a probate and there ends up being nothing left, just due to creditor claims, all the expenses, attorney's fees. But people will never be personally responsible for their family members or anyone else's debts. But the process of figuring out what debts are out there, that takes time too.
So, probate usually happens obviously when somebody passes away and then now they have these assets they have to get rid of. And so part, they're mourning like a loved one they lost. Now they have probate, so which is also like another thing. And then they just want to be done with the process. So usually they want to sell these properties as fast as they can. How soon can you sell a property in probate?
So a lot of times when I do my probate petitions, I ask the court to give my clients authority under the Independent Administration of Estates Act. This is one of the many fun statutes that I read for fun. But what we ask the court for is to allow this administrator, this personal representative, to have some independence and not go to the court for every single thing that they do. So when my clients do have this authority, they can sell the property once those letters of administration, letters testamentary are issued to them. What happens is my clients will work with a realtor. The realtor will send me the contract to sell the property. And we just need to notice the beneficiaries. We need to let the beneficiaries know that this personal representative wants to sell the property. And those beneficiaries, they have 15 days to object. If no one objects, then we can go through and sell the property.
Okay. So they got to have the permission from the court and then make sure everybody's been notified and then they can sell it.
Yes. And a lot of times, I don't really know exactly what your policy is, but you might want to make sure you see a petition that someone's actually been filed, or you want to see the letters that they have some authority, because we don't want some random cousin trying to sell the property that someone else is.
Well, one of the things I see on my end is one, they don't have a good attorney like you. And so they weren't properly, the court wasn't properly petitioned in the first place. So they get what we call letters of special administration, right? And they're able to access a few things and make some decisions on behalf of the state, but they don't have the full authority, especially like the independent authority, which you referenced. And so now the attorney told them that they can maybe sell the property, but when we have special administration, we can't sell it. So they're over here at my office trying to have me help them sell this, and we don't have proper authority.
Yeah, we will use, so that's kind of, it's within the realm of probate still.
Yeah.
Um, we will petition for special authority essentially when we don't know what's out there. So because we have these levels of probate that depend on the value of the estate, we will petition the court, ask for special authorities to allow people to investigate and see what we can find. Because sometimes maybe it's some random niece that was appointed in their aunt's will, but she lives in Tennessee. She has no idea what her aunt has. And so you do have to take the time and be like, is there a property we're looking at? Are there accounts? Is there a mortgage? And so sometimes we do want people to get their foot in the door and be able to investigate, but that's really it, is
Yeah.
allowing people to investigate. But the court's not going to let them sell the property because
Right.
the court needs to make sure these people are qualified to serve and make sure that they can engage in these big transactions like selling a property.
Yeah, yeah. So yes, usually what I'm looking for is I want to see that they either have, a general administration or they have the independent authority.
Yes.
Yep.
If people don't request to allow their clients to, sell properties with independent authority, that doesn't mean that they can't sell the property still. They still can. We just have to petition the court and sell the property. That is when we get into the fun overbid situation.
Yeah.
Essentially, the probate commissioner, they get the petition, we set it for a hearing, and he acts as like an auctioneer. He sits up there and says, we have a buyer. They want to buy the property for $500,000. And there's people who come on and they'll bid higher for the property.
Yeah, that's pretty crazy. I know, especially like in our market or right now in this market, it's a little different than the market what I call the COVID market.
Yes.
So we're not seeing so much overbid, but what we do see is the buyers kind of nervous about having to go to court for the overbid.
Mm-hmm.
If the state has that general administration, they typically, in my opinion, the property doesn't sell for as high a price as they could have gotten.
And well, they have to wait too to get a hearing, which takes, especially if you're in a general administration, we're waiting 5 weeks to get a hearing.
Yeah, especially around the holidays, even longer sometimes.
Yes, I had a probate. It was back in kind of late 2022. So I'd still consider that being the COVID market. And we petitioned the court to sell the property. Our buyers waited for 5 weeks and then it bid up $80,000 with 5 different bidders. So then we finally got our new buyer and they backed out 2 days before closing.
Oh.
So we had to do it again. And that second buyer backed out too. So we had to petition the court 3 times to sell the property. So there are these probate horror stories and it happens. If I think that my client is well organized and communicates well with their other beneficiaries, I will always petition the court and ask for independent authority so that they can sell the property sooner.
Yeah, I think that one simplifies it for the buyers trying to buy the property, but 2 helps the estate actually wind up netting more money. I know the overbid's nice, but not everybody knows you can go to court also and bid on those properties. So having the independent authority gives you like the ability to market the property and find the highest buyer right there.
Yes. I would say another kind of problem that I do see during probates is sometimes mom and dad, they pass away with a property and there's another one of their siblings living at the property. So when you have other people who live at that property, you can't sell it underneath them. We kind of get into a landlord-tenant situation where like there are situations where you have to evict people in those homes. I see a lot of those issues where people go and sell the property and then it ends up falling through before close because we can't get a person out of the property. So it's always a lot of disclosure that you want to tell your probate attorneys about to make sure that we can prepare. One thing that's great about Woodburn and Wedge is we don't just do estate planning and probate. We do have people who can do civil litigation. If this gets contested, then we have the contested attorneys who can deal with that. Same with contracts, and we do have people who can do evictions.
So probate is pretty messy. It sounds like it's a pretty long process and there's a lot of complexities to it. What's the best way just for people to avoid it?
Yeah, the best way to avoid it is to actually get a revocable living trust. So the reason why I'm sure you always hear like, let's avoid probate. And all the reasons we talked about, this is why. A will not allow you to avoid probate. A will is actually just instructions for the probate court. A revocable living trust, it actually allows people to take their assets and transfer it to the trust. So when the main people who form the trust, when they pass, they've already nominated people below them who can step into their shoes and sell the property. I don't know if you deal with a lot of sales during trust administration process, but I can tell you that it's much smoother and usually those clients are a little happier.
I mean, some of the services we provide to probate clients, we also provide to trusts because they're inheriting a house and, sometimes they got to get it ready for the market. And when you have that trust, I mean, the trustee steps in place and basically, I mean, it's as if the seller was selling it in the first place. It's the easiest
Exactly.
thing. They can make all the decisions. All the accounts typically are in a trust. That's a really, really nice process.
It is. Having a trust is great. The most important process is making sure that we fund our trust, which just means that's kind of the fancy lawyer word for making sure all of our assets are in the name of the trust. And when you do that for, your children, your beneficiaries, it's way simpler. I think people shy away from trust-based estate plans just because of the initial cost, and they are expensive to set up, but I will tell you that my probates are triple the amount of cost, if not more, as we've been speaking about all these different steps, all the process of it. And setting up a trust is way simpler than dealing with the probate process.
Well, and the process you're talking about is if it's easy.
If it's easy.
But once you add in like the different family dynamics and everything, that the processes just continue and the costs continue to go up.
Yes. When people pass away without anything, a will or a trust, we're having to deal with people who, they probably didn't want to get into this situation. I tend to find that at least when people pass away having a trust, their successor trustees knew that they were going to have to be in charge. They knew, like, oh, I'm going to have to administer mom and dad's trust. But when you have a probate, it's just like, oh, I guess I'm the most qualified. I guess I have to do it. So there is that layer too.
Yeah, that's tough. So real quick, why do people not get an estate plan and wind up finding themselves in probate?
Yeah, I actually think it is Americans' culture in general. Americans don't like to think about their own mortality. I don't know, even like when I talk to my parents about death versus like grandparents, you can kind of see the cultural difference. My grandparents were like, "Oh, that's not going to happen," whereas I think America's gotten a little bit better. So first is people always think that they're going to have more time. Second is they're like, oh, I don't have an estate. I don't have an estate to be administered. I just have a house, two vehicles, and two bank accounts. That's an estate. In Nevada, if you own real property, you need to have a trust. You need to have something in place. Also, I think people sometimes don't do trusts or an estate plan in general because their families get along. Death makes it hard on families. Death will bring out the worst in people. The saying is, death in marriage always brings the worst out in people. And so, sure, your family might get along now, but you don't know what's going to happen when people are gone.
Yeah, that's the toughest thing. So I think the best thing for people to do to avoid probate is to reach out to you. So I'm going to put your contact information
Yeah,
below.
yes, definitely reach out. We can talk about avoiding probate. Estate plans also add greater value than avoiding probate. If you have minor kids, we can make sure that guardians are appointed to take care of your kids. We can also ensure that when your kids are going to inherit money one day, they're not going to get it at 18. We can add some more restrictions. I don't think 18-year-olds should be getting a bunch of money. If I received a bunch of money at 18, I would have bought something dumb and silly. And let's, make sure we can hold it in trust for them until they're 25, when then they can go see you, Richard, and buy a house.
Yeah, definitely. I think well, that's another thing people don't think about. I'm young, I'm going to live forever kind of mentality. And realistically, a trust is a good thing to have because I could be driving and get incapacitated and now I can't make decisions, but I'm not, I'm not dead. And there's nobody that could really facilitate anything on my behalf. And that's part of having that proper estate plan.
Exactly. I'd say if you own real property, you need to have an estate plan. And if you have kids, you need to have an estate plan. A lot of people, when they get to retirement age, maybe they just sent their kids to college, they do start thinking about estate planning more. But I don't think people in their 20s to 40s really think about it because, it's not a problem. But a lot of people will think about it after dealing with their grandparents or their parents' estates, and they're exhausted after the probate, and they're like, I don't want my family to have to go through what I just had to go through.
Right. Yeah, it's tough. Well, I appreciate you helping us walk through this whole process. Is
Yeah.
there anything you want to add?
I'll just say that probate, it is long and exhausting, but it's not the worst thing that could ever happen to someone. And especially when you do have a trusted realtor, a trusted CPA, a trusted attorney who's with you on that. And so if you are in a situation you need an attorney for a probate, we'll make it as simple as possible for you.
Perfect. Well, I appreciate it and thanks for being here today.
Yeah, thanks for having me.